Thank you for watching our YouTube channel. Today's episode is going to be on funding your trust. Many times when individuals establish their living trust to avoid probate, they don't get the appropriate advice to transfer particular assets into the living trust. So what we want to do is talk about the assets that need to be transferred in and the importance of doing so. Certain probate triggering assets are real estate holdings and bank accounts. And now when we talk about bank accounts, when you add up the accumulative value of all the accounts spread across the checking, savings, and brokerage accounts, and these would be all the non-retirement accounts, if that balance exceeds $150,000 when you add up all those assets, then you would have a probate on the financial assets. So when we talk about bank accounts, we're looking at a threshold of about $150K. And then when it comes to real estate holdings, you're going to have probate on those assets. So when we talk about real estate and bank accounts, those are your probate triggering assets. And we need to make sure that those assets get funded or transferred into the name of your trust. What happens when you do not transfer these assets into a living trust? God forbid you pass, your successor trustee will make his way over to the bank and tell the bank to release those funds, but the bank, unfortunately, since the accounts were not part of the trust, will not release those funds to the trustee. They're going to say that these accounts never made their way over into the living trust by title. Please go to court and get the court's permission to have those accounts transferred into the trust. Now the problem here is we're going to have to go through the probate process, and that was the whole purpose of setting up the living trust, was to avoid probate altogether. When it comes to real estate, same thing. When you have title on a piece of property, and God forbid people pass who are on title, and that property was not in the living trust, that property cannot be sold. The title company will not allow that property to be sold because the decedents whose names are on title cannot sign off on the grant deed selling the property to someone else, or in that effect transferring it to the rightful beneficiaries. So that property needs to go through the probate process as well. What needs to happen after you get your living trust created is typically most attorneys, most law firms will have your real estate holdings transferred into the living trust by way of a quitclaim deed or a grant deed, transferring it into the living trust. So the title would be held in your name if you're married, in both husband and wife's name, and the new deed would show that it is now part of Kern Singh as trustee of the Singh Family Revocable Trust. That would now give, in the event I pass, my successor trustee, after they've gone through the trust administration part of the process, to allow them to transfer the property to the rightful beneficiaries or sell the real estate holding if need be to create liquidity. Further, if the bank accounts have been transferred into the trust, they can also go to the bank and deal with the banks. Now, most often than not, the attorney will give instruction to the client to go to their financial institutions to have their bank accounts transferred into the trust. What would need to happen here is, if you are a married couple, both of you will go down with your estate planning documents to the financial institution, whether it's a Bank of America, Wells Fargo, or a Chase, and you'll let them know that the accounts that you have with them, you want to have them transferred into the name of the trust. And these are all your non-retirement accounts. These are taxable accounts. The bank will take care of all the paperwork that needs to get done on the back end, and then ultimately those accounts will be part of your trust. As far as the Vanguards of the world, the Fidelities, the Charles Schwabs, you'll be giving their 1-800 numbers a call, have them send you the forms to have those accounts transferred into the trust. You'll be filling those forms out and submitting them back to those financial institutions. We, in our firm, part of our practice is to assist our clients with filling out those forms if they need the help, but those forms are pretty straightforward. Each institution has its own form, but simple task of filling it out, answering the questions that they're asking, and submitting them back to them. If you have any more questions, do not hesitate to call our office at the number above. You can visit our website as well to get more information. We also have plenty of blogs on this subject matter on funding your trust as well. Thank you for watching, and enjoy.